judgment room.
23145.
All right, we are back on the record following a brief bench conference. Ms. Heiss has joined us by Zoom, so let's go ahead and do appearances, please.
Lee Heiss, lawyer, guardian ad litem.
Ms. Taja Thomas, counsel for the department. Chelsea Grant for the department. Brittany Kelly for the department.
Michael McFarland, representing Monica Kerwiki. Mother, please introduce yourself.
Monica Kerwiki.
All right, on the sidebar, Ms. Thomas, any comments?
Yes, thank you, Your Honor. At the sidebar, I discussed there was an error on our GC04B indicating a non-parent adult respondent name. And so under paragraph G, I asked the court to consider that person, Katrina Lake, for paragraph D as the legal parent for Accuses Santiago. And then there was also the question as it relates to Hadass Harris. This individual is marked as a respondent, but Hadass was named as a guardian for Accuses, and I believe that there's a pending hearing on that limited guardianship. And given that it is a limited guardianship, the parent, Katrina, has the right to, I guess, petition the court at any time to revoke that. But to the extent the guardianship is resolved, we would not name Hadass Harris as a respondent. And then the question about the right to an attorney was also brought up, and clarifying that the legal parent is entitled to an attorney and not a guardian. And that is also another reason why, again, to the extent the guardianship is taken care of, we would ask to remove Hadass Harris as respondent for those reasons.
Any objections?
No objection.
Her name is Kerwiki, Your Honor, not.
Oh, I'm sorry for that.
Any objections to the other proposed changes?
No, Your Honor.
All right, any objections to changing Hadass Harris to Kerwiki?
No, Your Honor.
As well, any objection to dismissing her as a respondent in the matter?
No, Your Honor.
No objection.
All right, she is released then, or dismissed, and the order will reflect that. Deputy Ames, would you please swear in Ms. Monica Kerwiki?
Remain seated, but raise your right hand, please. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir. Okay. Ms. Kerwiki, as your attorney indicated on the record today, do you wish to enter a plea and take responsibility for the allegations to the petition by way of a no contest plea?
Yes, ma'am.
Okay. You have the right to have the petition read onto the record. Do you wish to have me read the allegations onto the record today?
No, ma'am.
Do you have any Native American heritage? Are you a member of a tribe or have any reason to believe that you'd be eligible for membership in any Native American tribe or be?
No, ma'am.
Okay. Other than the cases that have been indicated in the initial paperwork, do you know of any other legal matters that would concern your son, Xander Kerwiki?
Okay.
Do you have a copy of the petition?
Yes, ma'am.
All right. If I accept your plea, you are giving up the right to a trial by judge or trial by jury, the right to have the petitioner approve the allegations in the petition by a preponderance of the evidence, the right to have witnesses appear against you and testify under oath at trial, the right to cross-examine those witnesses, and the right to have the court subpoena any witnesses that you believe could give testimony in your favor. Do you understand you'll be giving up or waiving the rights I've just indicated to you if you enter a no contest plea today?
Yes, ma'am.
With regard to the consequences of your plea, or in other words, what will happen, the court will do the following. There will be continued investigation by the caseworker to see what the problems are in your family and how and whether they can be solved. The court could dismiss the case if there's no need for the court to be involved. If it appears there is a problem that may be solved, the court can make the children temporary wards of the court, place them with mother or father or with relatives or in a foster home, and order programs for you and your children, such as counseling, drug and alcohol treatment, assessments, and parenting classes. If it appears that you will not be able to provide a proper home for the child in the reasonably foreseeable future, the court could terminate your parental rights. In regard to the plea itself, the plea can also later be used as evidence in a proceeding to terminate your parental rights. Do you understand the consequences of your plea?
Yes, ma'am.
Do you have any questions about any of the information I've given you so far?
No, ma'am.
Okay. Is Is anyone making you enter a no contest plea?
No, ma'am.
Does anyone threaten you in any way to get you to enter a no contest plea?
No, ma'am.
Outside the terms of any plea agreement, which I don't think there is one in this case, does anyone promise you anything to get you to enter a no contest plea? Are you under the influence of drugs, alcohol, or any other mental or physical condition that could impair your ability to understand what you're doing here this morning? Would you say your decision to enter a plea is your own free will decision? Ms. Heiss, would you, considering the child's best interest, specifically Xander Kerwiki, for me to accept a plea from Monica Kerwiki?
Yes, Your Honor.
Mr. McFarland, would you articulate the grounds for the no contest plea?
Yes, Your Honor, there's current criminal pending activity on my client for the underlying domestic violence charges in the petition itself.
Your objection to the no contest plea?
No, Your Honor, I believe that is appropriate.
I have no objection.
Very well. Okay, Ms. Thomas, as it relates to the factual basis of the plea, do you have a witness?
Thank you, Your Honor. I would ask Ms. Grant to testify to the factual basis.
Stand, Ms. Grant.
You swear or affirm to tell the truth, the whole truth, nothing but the truth, so help you God?
Good morning, Ms. Grant.
Good morning.
Where are you currently employed?
Lebanon County DHS as a CPS worker.
And as a CPS worker, is that how you learned about the allegations contained in the petition?
I did.
And you drafted and signed this petition, is that correct?
That is correct.
And we, as a worker, were you also an investigator in this matter?
I was not. I was the ongoing worker for this.
And can you explain how you became the ongoing worker?
Yes, so in May of this year, I became the ongoing worker after an investigation was opened in April of this year. That investigation was opened for allegations of physical abuse due to an incident that occurred between Monica and her son, Z. Yes. And her son, Z. The incident did have law enforcement involved, in which charges were brought up for domestic violence between Monica and her son. That case was opened. During that case, there was another set of allegations that came in prior to the no contact order being put in which Xander had a cut on his hand, and there were allegations that Monica had grabbed his hand, squeezing where the cut was, causing it to re-bleed. Those were also investigated and tied into that investigation. That case was open then for ongoing services, which is when I became involved.
Thank you. And the April investigation, which led to a police report and then, I guess, charges for domestic violence. What were the, as brief as possible, what were the, I guess, allegations surrounding that incident?
So allegations came in that earlier that day, Monica and Hadass were upset regarding Z's probation and them not violating him for his probation. The conversation continued to their wraparound services program, where there was a disagreement during wraparound regarding that probation. Monica became upset, ended the session early, asked the wraparound worker to leave. Following that session, the police report and disclosures from the child and the family state that Xander had went to the car. While in the car, Monica slapped him 3 times. He was sent back into the home, into his bedroom. Following in his bedroom, he was asked to come down and do chores, where he got into a verbal argument with both parents. He states that at that time, Hadass slapped him in the face, which caused him to go outside. He reports in both the police report and in person that, or in his interview, that his face hurt so bad that he was trying to move the pain away from his face to any other part of his body, which is why he began punching the house. At which point Monica became upset, came outside. She uses the words restraining him. He uses the words choking him, where she was grabbing him by the sweatshirt into the house to have him stop punching the house, which left marks on his neck, followed by law enforcement responding and visually seeing the marks on his neck.
And as part of the pending criminal case, what are, to the best of your knowledge, the bond conditions, if any?
So the bond conditions were originally a no contact order between the two. However, the family was in IHT services and wraparound services, and with talking to the prosecutors and the judge, they did want those services to continue. The no contact was lifted to be able to take care of those services. However, it was still with the understanding that Z will not spend overnights at the home, will not spend lots of time at the home, that it will be very little and controlled visitation.
Currently, is the family participating in IHT?
They are participating in IHT and wraparound service. We did have another investigation come in about a week after that no contact was dropped. And based upon the findings of that investigation, along with reports from services, despite the family participating in service, there's been very little change, and they've been in these services for over 6 months. Incidents continue, while very sporadically. The longer Z is in the home, another incident or issue or confrontation tends to happen, giving us a setback. Sorry, just taking some notes.
Thank you. And based on the petition, it looks like there are 6 or so, several CPS investigations in which the respondent mother is named as a perpetrator, but only of which one was substantiated, which is the May investigation. Does that seem accurate?
Correct. There is a pending investigation that's not completely completed. It what goes along with Wildwood petition, but that will be substantiated as well.
At this time, this is kind of outside the factual basis component, but what would be the recommendation for parenting time right now?
We would like to do supervised visitation. We are also planning on possibly considering therapeutic visits instead of just IHT visits. But it would be a normal standard, 3 times a week, several hours, because we do want them to maintain and regrow their bond together.
There are other named children on this petition who have or are with legal parents. Do you have any updates as relates to further custody orders or anything of that nature?
Yes, we had conversations with both of them. Both are willing to submit ex parte orders this week.
But to the best of your knowledge, that has not been done yet?
I do not believe it has been done yet, as I think we had court Friday afternoon, and I'm not sure they had a chance to do that.
Thank you, Your Honor. I have no further questions of Ms. Grant.
And you're willing to have a family team meetings as soon as possible so we can come up with a service plan for a disposition, correct?
Absolutely.
Nothing further.
Ms. Hines, any questions?
Yes, when Xander was born, was his mother married to anyone?
I believe she was not.
Okay, no other questions, thank you.
You have one question, Your Honor. I think I remembered it from Friday. If my client were to leave the marital residence, would placement be considered with her wife?
It could be something we could take into consideration. I'm not sure we would do that immediately.
So is that something that you might come up with an answer before she moves out? Therefore, she would have to move out for you? to
Yeah,
consider that?
absolutely. We
Okay.
would come to that before.
Thank you. Nothing further.
Okay, thank you for your testimony. We are adjourned. Are the attorneys satisfied with the factual basis of the plea and the advice of rights?
I am.
Yes, Your Honor.
I am. Yes, I am.
The court finds the plea to be knowingly, understandably, and voluntarily made. I Further find that the record supports that one or more of the statutory grounds alleged in the petition are true. Specifically, the sections that the department is asking to consider do apply, which is 7128.2B1 and 2B2. I do find as a result of this child living in the home with this parent during that period of time, legally responsible for the care and maintenance of this child, has neglected to provide proper care as a result of the physical abuse that he suffered while in the home. And then, of course, under 7128.2B2, that physical abuse also characterizes this particular home or environment as a place that does have criminality and cruelty and neglect in part as well as a result of that physical abuse on the part of this parent, making that home at this time an unfit place for the juvenile to live in. Also find that the failed attention services or improvement as a result of those services contribute to the factual basis for those two sections to apply as well. The next hearing will be the dispositional hearing. You will be asked to meet with the department to put together a case services plan between now and when we come back. Give you a date for that. You could conduct the initial disposition on, get slided in potentially on the 23rd of August at 10:30. Does that work?
It does, Your Honor.
I believe so, Your Honor.
Your Honor, I have about 4 MCIs, but I think we should be done by 10:30.
Okay, good, thank you.
Rheta, do you have anything for the Herring, Leary, or Mulholland?
At 11. Is that at 11? I can't remember. Well, we can, I've been without an assistant for a minute, so it's possible that that's. So we can look at that after we're on the record today, make sure that that's not an issue. But we'll schedule that initial disposition for now on the 23rd at 10:30. So, Ms. Thomas, while we're on the record on this, today is actually probably the date and time also for the prelim, the remaining aspects of the prelim that weren't addressed last week. There are obviously 3 other children involved with the dismissal of Ms. Kerwiki. There was always one question, but if you could address for me where the other children are and what the plan is moving forward.
Thank you, Your Honor. There is a JK who was with a non-respondent father, and we would anticipate an ex parte. It's my understanding that that individual has sought one in the past and was denied. I'm not sure the reasoning for that. And as for EK, that child is with the non-respondent parent as well. And it is my understanding that parent would also be seeking an ex parte. And then as it relates to CS, that is the child who's under the limited guardianship, but I believe is now with the legal parents of that child at this time, and is also pending the guardianship hearing, I believe, on August 2nd. Until there are further orders from the court, we would ask that those children remain on the petition, given that the custody orders being Ms. Kerwiki as a parent with parenting time and legal rights, obviously. And so you just ask that those court remain under our court jurisdiction, those children remain under our court's jurisdiction, so we can facilitate any parenting time as well.
Is CS in the household of his mother or his father?
Mother.
Objection to that request, Mr. McFarland?
I think it should be unified.
Ms. Heiss?
I have no objection to that.
All right, so the order will reflect then, excuse me, the JK and EK and CS all will be placed with their non-respondent parents Subject to the jurisdiction of the court and the supervision of the Department of Health and Human Services for purposes of visitation until a lesser restrictive measure can be implemented. And we'll look for updates on that, of course, at our initial disposition, which will be on the 23rd at 10:30 in the morning. I'll have this order for you in a few minutes if you want to wait.
We'll wait out, call you on. Thank you.
All orders will remain in full force and effect.
Thank you, Your Honor.
Thanks for watching, and don't forget to subscribe for more courtroom cases.